Welcome. Today we're going to discuss an opinion issued by the Trademark Trial and Appeal Board in re Sarah Marie Duncan. My name is Scott Slavick, and I am the co-chair of Barrick's Intellectual Property Group. I have over 20 years of experience representing high-profile clients in all types of intellectual property matters. If you ever need help devising strategies to provide maximum international trademark protection for your brands, searching and clearing new global brands on a rush timeline, reviewing new marketing programs, or advising on risks with respect to social media marketing, I am happy to help. In this case, the TTAB upheld yet another failure to function refusal, this time for the proposed mark Mama Bear for various clothing items, including t-shirts and sweatshirts. In rejecting the application, the board concluded that ubiquitous use of Mama Bear, emblazoned in an ornamental manner on the front of t-shirts and sweatshirts by applicant and many third parties, supported a finding that the phrase Mama Bear would be perceived as a widely used message and not as a unique source identifier. The examiner submitted dictionary definitions of mama bear, a tough, aggressive, and protective mother, often going to extreme lengths to protect her child, usually her son and herself. Usage in literature, the story of Goldilocks and the Three Bears, and in media, the problem with mama bear syndrome, parenting magazine, and third-party uses of mama bear on clothing, often depicted as being worn by pregnant women in support of the refusal. Applicant pointed to some 19 issued registrations for marks comprising or containing mama bear for a variety of goods and services. Applicant argued that the USPTO was acting in an inconsistent and arbitrary manner in rejecting the application. The applicant also pointed out that the applicant uses mama bear in a trademark manner on hang tags, sewn-in labels, packaging, and invoices. In response, the examiner maintained that mama bear is a commonplace message or expression that is widely used by a variety of sources, especially when displayed in an ornamental manner on clothing. In its opinion, the board observed that the USPTO's policy regarding the registrability of widely used messages is summarized in TMEP section 1202.04b. Messages that merely convey ordinary familiar concepts or sentiments that are used by a variety of sources in the marketplace are considered commonplace and will be understood as conveying the ordinary concept or sentiment normally associated with them rather than serving any source indicating function. As to the registration cited by the applicant, the board pointed out once again that each case must be decided on its own record. In addition, the registrations, including one owned by applicant for its mama bear thing, merited little probative value because the registered marks are distinguishable from the proposed mark. Moreover, all the third-party registrations involved goods and services other than clothing. The applicant claimed that her use of mama bear preceded that of the third-party marks, and that the sellers are vendors who copied her design. The board was unmoved. Quote, that applicant may have been the first user of the ubiquitous mama bear designation is not dispositive on the issue of registrability, whereas here, the evidence shows that the term indeed is ubiquitous. As the manner of applicant's use of mama bear, the board noted that this usage was the same as others using the phrase on clothing. Moreover, applicant's hang tag contains other words and designs that appear as trademarks. The board found from the evidence of record that target consumers who purchase and wear this merchandise express to others that they exude protective maternal behavior. Mama bear is therefore a common, widely used, and generally understood term to convey a message of an ordinary or familiar concept or sentiment, aggressive, protective parenting. Consequently, the board concluded that mama bear did not serve as a designation of source for applicants' clothing products and was unregisterable under sections 1, 2, and 45 of the Lanham Act. A few interesting things to note. First, apparently a letter of protest containing pictures of many clothing items was submitted by Trademark Watchdogs, a self-described group of entrepreneurs in the e-commerce and print-on-demand space that specializes in letters of protest. It'll be interesting to know what role that played in the examiner's thinking. Second, ornamental refusals, especially when they come to clothing, is a real issue that applicants need to consider moving forward. It takes education from an IP attorney to really work with their clients to explain what would be considered ornamental and what will be considered trademark use. If you have any questions about whether your trademark use may lead to an ornamental refusal or any other trademark related question, please feel free to contact me. If you have any further questions, please feel free to contact me or any of the Barrick lawyers that you typically deal with, and we'll be happy to help